We're here for our next panel, and this is media at the bail stage. This is very defense-focused, very defense-focused topic. Not a lot of crowns are usually, they have a policy not to talk to the media. So if you're a crown and watching, you can have your nap now. And defense, we will be talking about media at the bail stage. Hi, Kim and Jennifer. It's very nice to see you. We had a lot of fun preparing for this panel because there are always some crazy stories that happen, especially when the media is around. And I think we wanted to start actually with you, Kim, sharing maybe some 1 or 2 or 3 crazy stories that you've had at the bail stage and the media.
So I thought you were going to begin by saying it's a crazy topic because not of the media, but because of me. But so let's so we started with this was saying that this is very much defense focused. Traditionally, yes, but I would say that as time goes on, less so, or crowns are more involved in this than they used to be. So it used to just be, you have a bail hearing, you get a 517 order, you don't really think about it too much because it's a fair trial right, and off you go. But we don't live in a traditional media age. So it is not always just requested, because we saw what happened in Umar Zamir. We saw a man's life on hold and really destroyed under this blanket of what ended up being a problematic prosecution and a situation that he was vilified largely for even having been released in the first place. So Justice Copeland dealt with some issues in that case about, so she released him and thoughtful reasons. So all of that, the release is reported, general conditions of the release are reported, but not the reasons for release. And as requested really by counsel at the time, and probably rightfully, and I'm sure thoughtfully. However, as time progressed, it became apparent that certain public officials, whether rightfully or wrongfully, but really glommed onto this as a political issue, and really used him as a lightning rod for gun violence and violence generally. Even though it wasn't gun related, but it's police related. So it was about violence in the city. So what do? You go back and you say to the judge, can we reconsider this? Can we open this up now? We have to tell our side of the story because there's another side of the story. And keep in mind, this is not a publication ban. It is a ban on the proceedings at the bail. So, but it becomes very tricky, because often the proceedings at the bail are also the same as the facts of the case. So what do you report? And that's where Jennifer certainly has some decisions to make later on. But the point being is this, is we live in a very different media age, and we live in an age where people have different interests. And the interests are not just their fair trial right. And that's an important interest, and maybe it's an interest that should trump others, but it's not the only interest. Now, on the other side of things, we have people sometimes in the entertainment industry that really want to talk once they get charged. And they want to talk about their bail hearing. They want us to make statements to the media. They want to use that as well, not just about they're wrongly accused, but use it for other reasons. So you have to, I would say you have to be mindful of the purpose of 517, but you have to take a more nuanced approach. And in a notorious rapper who was charged with a homicide, we actually did not request a publication ban, and the Crown requested it. And the Crown received a publication ban. But you also have to be very careful about not sacrificing the rights of your clients, because your client may not understand what's best for him and her, because him or her, but at the end of the day, it's their case that matters, but there's also considerations on the impact that case has in the interim on their life and on their career and their ability to just function pending the trial.
Yeah, I feel very honored to be speaking with you. Your reputation precedes you. I've been a journalist at the Toronto Star for the last 12 years. It's really great to be in front of a non-media audience, because I think when we kind of build bridges of an understanding of what our day jobs look like, and I say that in the like, I get up and go to work and I have to do a job, but then the things that we're really passionate about, it's great to sort of build up this understanding with one another. And Kim mentioned the Zamir case, and for us, it's like that's the case that keeps a journalist up at night. And it's the reason why I show up to bail hearings, because even though I'm not able to report on everything I hear or anything I hear, which is typically the case, it's so important to be there, because the story that my colleague Betsy wrote and my colleagues at other media outlets wrote, when it was possible to say what had happened to this man, was just so important. And I realized that that's not the everyday bail situation. It's not the typical 517 challenge. But for us, bail is about understanding the full picture. You often hear a lot of personal information, which it's important to say that I actually have a great amount of respect for the actual reasons behind these publication bans. I write a lot about youth cases, and I actually care about the idea, personally, I care about the idea of these young people having the opportunity to be rehabilitated. So it's not just a legal reason to not report their identities. For me, it's like an ethical and a moral reason not to report their identities. And the same goes for fair trial rights, where this is a system we have, and we spend a lot of time criticizing the overall justice system as, a media conglomerate. But if this is the system we have right now, then we do have a right to fair trial in this circumstance with the jury and the way that everything is set up. And so I just want to say at the outset, we actually do care about those bans, though they frustrate me every single day of my life.
So I just want to pick up on that for a moment, because fair trial rights, I think, encompass different things today than they encompassed, and I'm not sure how old Section 517 is, but I'm sure it's many, many, many decades old. So maybe we have to have a little revisit of that. And 517, and maybe we have to push the envelopes with our 517 requests, because although Justice Copeland said 517 doesn't give you the ability to have a modified publication ban, she allows for the possibility that not 517, but the common law jurisdiction to control your own process may allow for that. So I think I'm going to start requesting some of those modified publication bans. And the other issue is that we deal with all the time now, and I think this is a more recent, is the publication ban / sealing of addresses on recognizance. So many, many, many times I get requests from sureties, from accused, can you not put my address on? Person A is charged, is alleged to be a gang with whatever gang. Person B is the victim. Person B's gang's gonna want to know where person A is now residing. His poor aunt, who has no skin in the game, does not want this out there. And it becomes, I think we should be very, very mindful of that, because you have various websites now that just publish this, and they may not, and this is something else we should probably touch on, but they may not feel that they're bound as much ethically, at least, by 517 considerations, because whether it's an individual running a particular site or whether it's a group of individuals, 517 doesn't seem to have the same effect on all media partners, because the media is such a large concept now.
Yeah, it was such a good reminder when Kim and I were just talking about this particular issue in the hallway, because I said to her, from my perspective, is like what I would call like traditional or mainstream media. We're not often, there's very few reasons to publicize an exact address in a situation like this. You know, we always say like publication ban is publication ban. I still want to know that information. I still want to receive the court information and myself be able to assess where do these people live. But there's not a situation where I would say so-and-so lives at 123, you know, Smith Street. But when you talk about people publishing things to Reddit or to some of these blogs that Kim's talking about, you know, these people are not on the court joint media list, and do not have the same ethical considerations that I just explained to you every day. And it's interesting because when you're talking about media at the bail stage, you're no longer just talking about me and my colleagues. You're talking about people who have zoomed in, are savvy enough to figure out how to access bail papers. And there's a real risk of harm there. And I've started to notice in court, you know, for example, I've been covering some youth cases, and the justices that that have been handling these cases have been extremely worried about the Zoom access. And it's so much so that it's become a problem for me as the traditional media observer who sometimes needs to zoom in from various places. But it speaks to, I think, this sort of changing dynamic of the media landscape that it's important for especially new defense lawyers to be aware of. You know, when you're talking to me, we can have a conversation, you know, off the record. We can talk about things where, you know, I'm upholding a certain ethical code. But when you're talking to, you know, a non-traditional, someone who presents themselves in the media landscape, they may not follow any of those rules. And so, yeah, it's really about like those individual, I think, relationships that you have with a journalist these days. You know, I can only vouch for myself and my colleagues, but it's a really tricky time, especially with hybrid hearings, to try to protect the information that needs to be protected. While at the same time, I actually think a lot of information that, you know, talking to the defense counsel here, that's actually very sympathetic to your client would actually be wonderful for us to be able to report, but it's such a blanket ban. We have no, as media, we have no obviously recourse with something like a 517. It kind of becomes like this kind of wide paintbrush that it doesn't, I believe, doesn't necessarily need to be, but I don't know if we're here to
So-
change legislation.
Yeah, but I'm not sure it is. So it is about your ability to report on what happens there. But let's say statements to the media. You just do your bail hearing, your client gets released. And if the media is there, it's probably a reason for the media to be there. And as their lawyer, what do you do? First of all, what do you do that is not contrary to 517? Because you still can't say, well, the justice of the peace heard that the case isn't very strong and that's why they released. If there's a 517, of course, we can't talk about that. But you can say, and you don't need to, it doesn't need to just be my client maintains his innocence and we'll see you at the trial. I mean, you can make comments as you see fit that are, because 517 only, it doesn't cover evidence that may exist otherwise. It covers what happens in the bail hearing, the evidence that's called, the submissions that are made, the decision that is made. So that's what is covered. But you may have another idea of the case. You may know that there's 7 other witnesses that say the complete opposite of what the Crown says. And they either have or haven't been interviewed by the police, but you want to say, look, there's a number of other witnesses that saw this. We'll be hearing about that as the trial unfolds. So I would say you should, just for the integrity of your defense, you should keep that a little close to your chest, but there may be some utility in getting ahead of it. There may be, but also don't do it off the cuff. You've got to, so if you're doing a serious bail and it's a number of days, you have some time to prepare for it anyway. And you should be preparing for it. You should have, if you have a real idea of the direction, you may want to make some comments, but the direction of the case should not be based only on talking to your client. because sometimes they have a very different perspective on what actually is the evidence against them. So we should be very circumspect in that, but you don't have to be entirely silent on it. And I think that's what we're talking about, which is sometimes it's better to get ahead of it a little bit. And especially because what happens in today's day and age with if someone has a career, and this is, the media is there anyway, and the name's been published, in order for them to go back to work and to somewhat carry on their day-to-day, they may need something said at some point, other than waiting 2 years down the road, because most people can't just put their lives on hold. So those are all considerations, certainly, on the degree to which you engage the media.
Kim, I have a question though.
Sure.
What, as a defense lawyer, can you do when it's your client who's posting online about what's going on?
I know.
Because it happens.
Yes.
And despite the advice that we give them. So how do you manage?
Yeah, so that's, I think, not so much a 517 order as much as it is just controlling your client, right? So you've got to have them in and you've got to just sit them down. And the other thing that repeatedly is a problem, which is the posting of various portions of disclosure. Or because they're in looking at their disclosure, you're not watching them all the time. They're taking a picture of this, they're taking a picture of that, even though you don't, I mean, you're not giving your disclosure. I mean, you're not monitoring all of the time, sitting there monitoring. So there are circumstances. And what about you're not subject to an undertaking when those synopses go out. And so this is often, those synopses are the complex summaries that you get in project cases. Those get out, and what do you do with those? Those, because there's no 517 ban yet, you haven't had your bail hearing. And if you're reviewing items with the sureties have to see that, and you send those things to them sometimes. So you have to be very careful about what they say, and because it can be evidence against them for sure. But it also can strike at the integrity of the whole process. And I think that's a big problem. And the reason why, and you also, I want to just say a couple of this back to the crazy stories, but you don't want to be part of the process. Okay. This is the big thing. You don't be a dupe of your client. You're not their friend. And be very careful whose wedding you go to and who's like party and christening for their kids, because those things, this is a little off the 517 topic, but those things, although it can be, trust me, so those things sometimes find their way in disclosure and sometimes find their way even in bail hearings. So there's one bail hearing we did recently in which there was a defense counsel pictured with a gang sign around a pendant that the Crown alleged was a gang sign, but he wasn't wearing it. His lawyer was wearing it. So it had been placed on his lawyers, and it was like a funny picture, but it was going around, and the Crown was going to lead that. It was part of the bail hearing. And it would be led for purposes of proving the case against him potentially. So this is a problem. That case is long over at this stage, but it's a problem for people. So just to be very aware of what position you put yourself in, because it can wind up not just embarrassing, but as evidence against your client.
Never thought accepting jewelry from a client was going to be like top of the list of this, but yeah.
But especially when it's large and encrusted.
Yeah. Yeah.
Just don't accept.
Say no. Okay, good to know.
But so how can you, from a defense perspective, use the media to your client's advantage? And especially that it's still early. I mean, in some cases, the theory of the case is not fully crystallized. So how can, and actually, should lawyers not talk to the media at this stage at all and wait?
Well, I think it really depends on your case. And it depends on how much initial exposure your clients received. So if there's no initial exposure, you probably shouldn't phone up newspaper and or whatever media source. But if they're already there and they're going to report on it in any event, it may be a situation where you want to make a brief statement that it's traumatizing for this person, their family. They'll be, so these are the types of statements that often are made. But you don't want to be the news is the whole point. Now, theoretically, is there a possible situation where you want to make a media statement? Maybe. But those are usually made at the end of a case. Because, you know, Mr. Zamir, he was interviewed himself. So sometimes those kinds of things happen. And maybe you want to make a statement theoretically, but it would be something that would be the rare circumstance and a very considered statement. And I would say if you do that, you should have a fresh set of eyes look at it to just make sure that it is appropriate, that it's not contrary to a 517 order, and that it helps your client, not just now, but helps your client or doesn't hurt his case later.
My advice is always talk to us, but I will say, because this is about like kind of fostering like a better understanding between everyone, and like I can understand and have been in situations numerous times where it is not in your client's interest to talk to me at all. But I'm already there and I already know about the case and it's just a no comment. But I will say that, especially when it comes to my broadcast colleagues, they have such a hard time with Canadian court stories, as you can imagine, because there's so few visuals that they can use. And they are dying for just like a 5-second clip outside of the courthouse. Even if you agree to like walk past them outside of the courthouse, that honestly helps them and it will bring like better rapport with them. And like, you might be like, oh my God, I didn't like prepare for you to be out here. I don't want to walk past you on camera, but it honestly would like really help their story. For me, it's not as important because I just describe what I see. But I think that there are a lot of things that you can say that still reflect your client in a positive light that do actually add to our stories. You know, like I can't imagine what Zamir's counsel was going through, like what they wanted to say to us every day outside the courthouse. But I think by trying to like remind people that your client is like a human being, has some humanity, has a family, like all of those things for us, like we take those things because they help with readers' understanding of the story. They give a bit more context. I get to have a new character, which is you, the lawyer in the story. It helps flesh it out a bit. So it might seem like, oh, what's the point? I'm not saying anything. And what I'm saying is it helps, like even just walking by the camera.
Yeah, and I think, I mean, just picking up on that, media relationships generally. So at the end of the day, you have to work in your client's interests and you have to get their instructions on things. So sometimes we have, some of you may be aware, there's a number of racial profiling cases that I've been working on, and we've won 6 of them. And those are cases that literally I've handpicked from many cases. So it's already gone through a vetting process. I already know we're in a good position to prove certain things, and this is where we think it is. And we're not making these allegations without like a basis. So we've had the media very much involved in those cases because it shows a pattern. And at the end of the day, we're trying to, I mean, from my perspective, we're trying to move the needle a little bit on that and have a little exposure and maybe some reaction from TPS, and then maybe some training, and maybe we move beyond some of these issues. That's at the end of the day. But in the course of that, you have 6 people that are 6 young racialized men. You have to get them on board. Number one, you got to get them on board, generally that you're going to make this argument. Most of them, you don't have to get on board because they live that reality anyway. But you also have to say, look, if we do it this way, and I include you in this group, it's going to involve your name being published. And what does that mean to them? And so what I have done as a practice, because they're usually in their 20s, I don't take their word on it because their family's also involved. So you had to sit down and have a community discussion. And what you find more and more is not only does their community want to be involved, but they show up in court and it's all now a big thing that they are also part of. And the media relationship is important. And you better hope you win those ones. But it is about working cooperatively. And I think that that's really one of the main thrusts here is that reporting should be accurate, should be true. And the best way to do that is to be able to have the perspective.
Yeah, and just to like add to that, I completely agree with like how Kim sort of framed that. And it's so challenging for us just at a very basic level to get information from the court some days. You know, some days I might just be trying to get the court information and like nobody in the courthouse, especially at Armory these days, just like wants to help me. And when it comes to, you know, very like basic public documents, like the court information, again, like pub bans and everything included in that, like again, pub ban, but we're allowed to access the information. We really lean very heavily on defense counsel. And actually sometimes the Crown's office more recently, for example, I'm covering like a youth case where it's been so hard to keep up with the dates because there's multiple accused. And I don't think she'd mind me saying, I've been leaning on one of the Crowns to help me with the next court date, because that's not secret information, right? I just want to show up to a youth case and they don't post the youth dockets online. It's driving me crazy. And when it comes to at the bail stage, sometimes it's helpful to know what is happening behind the scenes. And I appreciate that that has to be a discussion you have with your client. But if they do agree and, you know, you're able to tell them, I know this reporter, I trust this reporter, it would be helpful for her to be able to follow along if she knew X, Y, Z. We really appreciate that stuff. And we don't forget that stuff when we're able to be brought into like a place of trust where we're given information we can't report, but it helps us either like logistically follow along, because sometimes, as you know, things get discussed behind closed doors at JPTs or just with the Crown in the hallway, and then stuff gets said at the bail hearing, and I'm like, whoa, what just happened there? And it's helpful to have that context so that I know where to direct my reporting. And issue stories can be challenging because, like Kim said, we will publish your client's name, but our focus is going to be on the issue at hand, whether it be racial profiling. I have my colleague and I have a case right now where the main witness for the Crown is a Toronto police officer who's been in a bit of trouble lately, and they've made an application to note they do not want to testify, and they're claiming PTSD. And it's like thrown this whole guns case up in the air. And for me, like whoever the accused was in the case is almost like a side story to what's happening. Yes, that person does have like active gun charges, and that probably seems from like their perspective and the defense's perspective, like, oh no, like Toronto Star just showed up. But it's like, I don't even know if those charges are legitimate, right? Because of the kind of cloud around this police officer who is the one that arrested him. And so it's helpful to know more information in situations like that, where your client actually is, I'm not even really concerned about your client, nor do I want to like malign your client in the paper if he's not actually going to be found guilty or charges are going to be withdrawn, et cetera, et cetera.
So this is actually a very good point, because we had this one, this is where we get to the war stories, I guess. But there's the open court concept and media attention and relationships are all important. So sometimes I'll phone because media will have no idea. For instance, there was an officer, Sansoni, who was an officer who had stolen drugs from a drug locker and did the drugs in the parking lot of the police division. This is, nobody knows this, but did the drugs there and had an overdose and had brain damage. And then there was a big prosecution. They called him. The Crown didn't state charges and they took the position, we should be very happy, there's less drugs now. And that, of course, wasn't our position. So we cross-examined this officer extensively. And in the course of cross-examining the officer, we had to bring a systemic argument about the way in which drug lockers are kept. And then it came out that there was a homicide detective as well. And it's the same locker within 30 days had also been accessed many times and drugs stolen. So doesn't matter about the accused. And the fact that these are two matters that, I mean, my position is that they were very delicately managed to keep them out of the media, to police officers. And it's not even about them because it's a very tragic story about them, but it's about the systemic, the indifference to the way that these drug lockers, everywhere else is videotape, but you know what? Those drug lockers, we're going to not put video there, which it seems, and it was one of the only areas that's not under surveillance. So those, and there was a OPP investigation, which of course was not also publicly known. So Wendy Gillis did a story on this, but so those are points that where I think the media can assist. And my client's name did not, wasn't even in. And that was one of the conditions. So you can also negotiate. So this is the thing about open court. Yes, we need an open court. You have different interests. This doesn't apply to 517. But if you have an issue that you think is really important, you can approach someone in the media and you can say, look, I have this issue. I think it's important. My client thinks it's important, but can't have his name published. So you can publish, an accused on project A, B, and C, and then what's going on, and there can still be some coverage. And what does coverage do? Coverage, I think, from my perspective, at the end of the day, develops you some change. So then somebody's looking into this. Why is the OPP report just sitting there on someone's desk? Why is nothing being done? What's going on with these drug lockers? Are they actually properly surveilled now? Is the record keeping better? So that kind of media attention moves those issues forward. And otherwise, everyone's very happy to just lock it in a cupboard and keep it there and hope it doesn't happen again. But hope springs eternal. But I think that some media coverage on these important issues is super important.
Yeah, I think what you just done is essentially like a public interest analysis, right? Like,
absolutely.
And when you just really rewind to the beginning of what I'm doing, why am I a journalist? Why am I in court at all? And it's when you are presented, if Kim calls and says, look, I got this client, he was wrapped up in whatever drug, gun, etc. bust, but something really weird is happening at this trial. I think there's public interest, but my client doesn't want to be associated with this gun charge. I'm going to try to get him off, etc. And, if I say, okay, well, let's tell me off the record, what's the story? And Kim were to say, well, there's a bunch of guys, cops stealing drugs from the locker. I no longer care about your client, right? Because if I'm just purely looking at it from a public interest, there's not a ton of public interest in a single person, especially if there's no victim, right? If the victim is not a homicide case. If you just look at that purely from what's the story here? If I tell my editors what Kim told me, they want the story on the dirty cops, obviously, right? So it's that's the way in which when Kim's saying we're cooperating, it's mutually beneficial. She's exposing something that she sees as wrong, which it is wrong. Her client doesn't have to expose himself to the negative association with having been charged in what may or may not be a bunk prosecution. And then we are telling a public interest story, which we have an obvious interest in doing, which is about people in positions of power, like the police, misbehaving.
Right. And it's not, and as much as this may surprise some people, I actually feel bad sometimes for the individual officers that are caught up in this. It's really unfortunate. There are two officers that had drug issues, but it's not about them. And I would even say, you know, maybe avoid publishing their names. Like, it doesn't really matter about them. It matters about the accountability of a system that knows its problems and even has external. So we're very good at we seem to be very good at bringing in external investigators. It's just what happens with those investigations later. And so that's the kind of thing where I think the media and defense counsel, because I'm not sure that necessarily the Crown has either an interest in keeping it under the radar or an interest in exposing it. They should have no interest. So the Crown should just do their job. So they can't really, and this is why maybe we started this by saying it's a defense focused, because the Crown should have no interest. And it's not really interesting if they have no interest. So why would you talk to the Crown? So that's the baseline, I would say, which is the interest should be that of a public interest. And as defense counsel, we bring that to your attention, but the Crown should remain really silent on these points.
Thank you so much, both of you, for this wonderful discussion. And we were very happy and lucky to have you today. And for everyone else now, we have a break before our next panel, which is on the case law on bail and bail reviews. Thank you.